medicine,
law, friendship. This is Dr. Long and lawyer Nick. You're listening to the Medico-Legal Brief.
one doctor, one lawyer, and a whole lot of gray area.
Welcome back to another episode, everyone. I'm really excited for another discussion here. I think we've got our more fun, less serious episodes, but wanted to start us off here, and we're out in Canada. I'm actually taking a family vacation. I'm working on vacation time, but honestly, this podcast has been kind of fun to do.
I think back when we had our PTO podcast, you were talking about this trip and you're like, okay, we're leaving in 2 weeks. And you went with the entire family, right? So all four of you?
Yep, kids and my in-laws too.
Yeah. Oh, your in-laws came as well.
Well, my father-in-law, yeah.
Okay. So has that been... Okay, so I have only traveled with my parents. I've never actually traveled with my in-laws. Has it been fun? Have you guys been enjoying it? Is it kind of like a built-in babysitter?
Kind of like a built-in babysitter, but honestly, my father-in-law is so chill.
Yeah.
He goes with the flow and does whatever. So very easy to hang out and talk to. And actually, we've been doing these 1,000-piece puzzles pretty much every night now as a family. It's been kind of a nice way to bond and discuss and kind of chit-chat about random things that come up while we're sitting there trying to focus in on matching colors to colors.
Have the kiddos tried to play with the puzzles at all? Like, have you had to kind of push them? I'd say, like, do not mess up the puzzle.
Yeah, we relocated from the living room where they had a sit down like coffee table because the kids were able to reach it. We moved it into the kitchen because then we figured the kids would stay in the living room. No, they followed us. Then we moved it up onto the dining table. We've had a couple of relocations to avoid any little hands going in and stealing puzzle pieces.
Nothing like getting to the last piece and you realize that like one of your kiddos ate the piece or something like that.
Exactly. And again, not our puzzle pieces, so we've just been really cautious about it.
Cool. Well, not much has been going on here in Texas. Obviously, we record these podcasts and then release them a few weeks later. But in our household, we are gearing up for college football. It's one of our favorite times of the year. And so we have 2 more Saturdays, and then we are at the Texas-Ohio State game. So we're not going to the game. We're staying here in Texas to watch. And me being a Texas alum, it's an important start to the college football season. So we're excited for that to begin.
Nice. Yeah. And I guess it's the first year that she won't be able to drink because she's carrying.
Yeah. Yes.
Yeah.
And actually, the funny thing is this Saturday, she signed us up to go to a pregnancy expo. We're going to a place, I think, in Irving, which is a place in DFW, and they're doing a big old pregnancy expo where they have all the strollers and they have all the baby gear and they have some talks. And I think that one thing that we found difficult about trying to prepare for our baby girl is the fact that there's no like bye baby or babies are us. So it's really hard to go out and kind of test product and see what you have. There's been a lot of ordering several different products from Amazon and seeing how they feel, seeing how they move, seeing if it's something that we want, and then sending back the rest, which a lot of people do in this day and age because those stores no longer exist.
That's the amazing thing about Amazon these days is it just makes it so easy and accessible. But you're right. There's just so many different baby products. I think best is obviously anecdotally. So if you have family friends that can recommend anything, that would be the best. But remember to set up a baby registry because Amazon also sends you a ton of free items too when baby comes.
We're definitely excited. I'm excited to get my hands on some of this stuff because I got some ideas on strollers and cameras and baby monitors, and I just want to play. I like gadgets, so I think it'll be a fun Saturday with the wife.
Cool. Well, let's get started on the episode here. And so our topic today is actually going to be just medical and legal jargon or definitions that I feel like we hear all the time when we're watching shows and movies, and sometimes it kind of makes sense, but I'm actually really interested in hearing the official definition of some of these terms.
When you're going through school, you hear these words, but for the general person out in the world, and this is for a lot of words, you hear something and you have an idea of what it might be or its use. So you might know when it's maybe a serious term or a lax term or something that is kind of ancillary or synonymous to something. But I think this is a great opportunity because I honestly think that your words that I have for you are a lot harder than the words that you have for me because it's doctor speech. It's, the way it's medical talk.
That's funny because when I was looking up terms that I was going to ask you, I was like, some of these, I don't know. These are kind of hard. I don't even know if Nick would know them. And then I realized, of course, Nick knows them because he's the lawyer. I guess we'll bounce back and forth. I want to start off with the biggest arching thing because I know that there are two terms that are used to refer to lawyers, and it's attorney versus lawyer. So what is the difference, and in what scenarios would you utilize them?
Lawyer versus attorney, they're pretty synonymous. Everybody uses them interchangeably. If you're trying to get technical, the technical way of it is lawyer is somebody who's just graduated from law school. They have received their Juris Doctor, they've gotten their JD. Essentially, you are a lawyer once you graduate from law school and get your law degree. An attorney is somebody who is licensed to practice law in a certain state or in a certain district. Now, I don't know how that extends into the international scope. I know that because of the fact of it being a doctorate, in some places in Europe, their lawyers are actually called doctor, just like somebody who's received their PhD is a doctor as well. But here we don't call our lawyers doctors. If you graduate law school, you are a lawyer, but it doesn't mean you are an attorney. However, if you are an attorney, that also means you are a lawyer. When you go through law school, you don't have to go and take the bar. You don't have to go be a licensed attorney. You can just stick with your JD and still have a successful career in anything you do. Or if you fail the bar exam, you can still move on and do other things. It's one of those things where it's just synonymous. And when it comes down to it, the lawyer versus attorney conversation can sometimes be leveraged in practice. How do I state this appropriately? Like if you're telling all of your friends that you're an attorney, you can come off as stiff or a little bit aggressive than rather just saying, yeah, I'm a lawyer. But then sometimes there's time and place for you to actually throw that attorney word around when you're really trying to like stick it to somebody. You know, the I'll be talking to my attorney about this has a little bit more flair than I'm just going to talk to my lawyer about this.
Great.
All
What do you
right.
got for me?
Okay, it's kind of the same thing. I've asked you this question several times. What is the difference between an MD and a DO?
Yeah. So MD is a medical doctor, the traditional doctor that most people think of. A DO is a doctor of osteopathy, and that is something that has kind of branched off from an MD. We go through the same sort of training. We do medical school, and then we do residency. And in fact, we actually do the same types of residencies. So I could be training alongside an MD, becoming a family physician or becoming a surgeon or becoming an OB-GYN. Like we could all be going through the same path and come out and do the same thing. The only difference is originally when DOs branched off of MDs, it was this idea of holistic medical care. So instead of just viewing the patient as a diagnosis or a pathology, we kind of took the whole body in as a whole. So patient comes in with neck pain, like we're not going to just give medication for the neck pain. We're going to try to figure out why is the neck pain there and how do we prevent it in the future? And are there any other tools that we can utilize to help prevent it down the line? The extra training that a DO gets only occurs in medical school, and it's a very small subset. It's one single class that we take in addition to our typical classes. So instead of, we're not only doing pathology, we're not only doing anatomy, but we're also doing a class called osteopathic manipulative treatment or medicine. And that's basically a hands-on modality, kind of a mix between chiropractic techniques as well as massage techniques. It helps realign the body. So we're really good with textures, and we're very comfortable putting our hands on patients to feel different changes in the muscles and anatomy. And essentially, it gives us a little additional teaching or learning on anatomy itself too, because it kind of goes hand in hand. Mm-hmm. But that is literally only difference between DOs and MDs is that additional class, because nowadays even MD schools teach that very holistic model. So really, people who go into DO school are typically the ones that want to learn that hands-on skill that MDs do not learn. But as a DO, you can become anything you ever want to be, whether that's a neurosurgeon, whether that's a psychiatrist or pediatrician. You can still become any sort of physician you want to be.
So can a DO also be an MD, or is it just the distinct separation?
Nope, distinct separation. And I would want to say 5-6 years ago, DOs and MDs actually had separate residencies. So DOs had their own separate osteopathic residencies and MDs had their own MD residencies. But DOs were allowed to jump over to MD, and we could also do an MD residency, but MDs are not allowed to jump into DOs because of the distinction that we had that extra training that they did not have. So we had all the basic foundations that an MD does. And so we were able to jump into an MD residency, whereas MDs didn't have that osteopathic training to jump into an osteopathic residency, because then when we took courses or learned things about osteopathy, they would have no idea what we're talking about. But now, because we have merged the two, residency is now just one cohort. You will go into whatever residency you want to, and you get a mixture of MDs and DOs, and they have now separated that osteopathic skills and learnings in residency to only the ones that actually want to continue to pursue it. So it's no longer mandatory, and that's why we've merged it.
Okay. And you are a DO, correct?
And I am a DO, correct. And I am a family physician who actually still practices OMT or OMM on a daily basis to just make sure that another tool that I can utilize to help my patients. And I use it a lot for neck pain, back pain, headaches, a lot in OB, patients who have a lot of pelvic pain.
I remember you've visited several times, and with me and the guys, we're always getting injured because we're either doing something stupid or playing sports or lifting weights. And you've kind of always been like, well, instead of just taking pills, let's see if we can massage that area out or stretch it out, or almost like a physical therapy PT of focus on the area instead of just throwing Tylenol at it, and let's see if we can actually fix it and get it right. So I've always appreciated that with, how you've approached our problems, at least.
Right. Yep. On to some law terms.
Yeah.
I'm going to throw some easy ones at you first. So we hear this a lot on TV and shows. So plaintiff versus defendant.
A plaintiff is somebody who is bringing forth the suit. When you see a pleading and it says Long is the plaintiff because he's bringing the suit, and then Nik is the defendant or respondent. So depending on where you're at, generally there's a difference in law between civil and criminal. And we've talked about this before, where I can sue my neighbor, I can sue a company, my neighbor can sue me, the company can sue me, and that's usually civil. But then you also have the criminal atmosphere of, well, if I break the law, the state can then pursue action against me from a criminal standpoint. Generally, you will not see respondent in the terms of criminal. So a respondent is somebody who is responding to the plaintiff. Defendant, obviously, we've all watched TV shows with somebody being in court, being tried for something, whether it be a murder or a bank robbery. And so they are the person that is defending themselves. They are the defendant. So hopefully that clears it up. If you're going to sue somebody, you're the plaintiff. If you're getting sued or the state is pursuing criminal action against you, you're the respondent or the defendant.
Got it.
And that's at
Makes
least
sense.
in Texas. Obviously, that can vary from state to state. Depending on certain areas, they might have more specific or more synonymous terms that they use.
Great.
All right. So my next one, diagnosis versus prognosis. I've heard them several times with my own physician. So what's the difference of the osises?
Yeah, the osises. Yeah. So you will learn that in the medical world, we use a lot of root words to help define, and then we expand from that root word. But with diagnosis is the actual defining pathology. So you are diagnosing this issue. So if it's neck pain, back pain, the diagnosis is neck pain, or the diagnosis is back pain. Or if you want to be even more specific, it is cervical radiculopathy versus a muscle strain. So if you want to diagnose, you're being very specific and you're defining the medical issue. Prognosis is the outcome. So what is the positive or negative outcome of that disease? So what is the prognosis of this specific cancer? The prognosis is you're going to live another 1 year, 2 years, or the prognosis is very good and it is treatable. So prognosis gives you kind of what the outcome is. Diagnosis is what the disease process or what the disease title or definition is.
I guess because they're so close in terminology, somebody could legitimately be sitting in the room, hear the prognosis and say, oh my gosh, I'm going to die like tomorrow.
Right.
And it's like, well, hold on, wait, that's not exactly what's going on. That's not your diagnosis. That's just the prognosis of, the future.
Correct. Yep.
All right. What do you got for me?
So tort. I think you've used it a couple times already, and I think a good definition of it would be helpful.
A tort is essentially a wrongful act against another. That's not criminal. It gives the other party the right to sue for something. I always found this interesting in law school is that torts and criminal law can intersect. For example, let's talk about battery, the act of hitting somebody. So I have touched you in an unwanted way. Well, I can sue you for the tortious.
Don't do that, Nick.
Yeah, don't do that. You gotta be careful with the doctors, especially the DOs, because they're really good with their hands. So you gotta be careful. But if I come up and I flick you, I've committed a battery on your person. Now, the state can have penal codes and laws in which that is a criminal act. Me flicking you is a battery on your body, and I can be arrested for that. Now, I also have civil recourse, which says I can sue you for the tortious conduct of battery. So even though there might be a criminal case, there can also be a civil case in which I sue you directly. And that's something a lot of people, I think, don't understand. And the standard is definitely different, right? So in criminal law, the standard is beyond a reasonable doubt. You are being sentenced because the jury has found you guilty or the judge has found you guilty beyond a reasonable doubt. Well, the standard in civil is more of a 51%, 49%. If I can just get that little bit of an edge over you in my evidence and in my pleadings and in my testimony, I win, you lose, essentially. You'll see a lot of times where the state may not be able to find a party guilty for battery based on the evidence, based on the testimony. Civilly, you could win a case regarding battery and end up getting damages from the other party. 99% of the time, those damages are monetary in value. You're not going to throw somebody in jail because of a civil act unless there's a criminal instance tied to it. So you can go down the list. A lot of the torts that we walk through, you have like your kidnapping, you have your assault, you have your battery, you have your stealing, your robberies, your burglaries. And then, of course, you get into the portion of negligence and duties of care. Usually you're dealing with plaintiff's lawyers, a personal injury, so on and so forth.
Got it. Great definition.
All right. The next one I have for you is acute.
Acute. All right. Well, if you're going to use acute, we have to pair it with chronic, right? I think you probably have that with you. So acute and chronic. So they are basically the opposite of each other. Acute is something that is just started in the short term. So it's usually defined by within 3 months in the medical world. That can change depending on which diagnoses were created. So whatever diagnosis you were given, that may shorten or lengthen what the acute phase is considered. But typically, if you are within under a 3-month period, you are considered in the acute phase. Now, chronic is a longer lasting disease process. That is a diagnosis that has lasted longer than 3 months. We're talking if you have, let's say, hair loss for the last 2 to 4 weeks, you notice that your hair is falling out more. That would be an acute hair loss diagnosis. Whereas, say, you came to me and you said, I've had acne for the last year and a half. That would be considered a chronic diagnosis of acne because you've had it for longer than 3 months. That's it. It just is an adjective to the diagnosis. Most diagnoses have an acute phase as well as a chronic phase.
I feel really, really dumb after hearing that. But when I've heard acute before, I always thought that it was just not time related, but more like strength related. If I come in with shoulder pain and on a scale of 1 to 10, with 10 being the worst pain ever, it was a 2, I would assume that would be acute. But if it was a 10 and I feel like my shoulder's about to fall off, that would not be considered acute. But what you're saying is, regardless of the pain level, or I guess the pain scale, if it was under a certain period of time, that would make it acute.
Correct. Acute and chronic defines the length and time, not the severity of disease.
Severity, that's the word I was looking for.
Yeah.
Okay,
so you can come in with a shotgun to the arm. That would be an acute trauma incident.
Really?
But if you came in a year later and said, hey, I was shot a year ago, then that would be a chronic trauma.
Wow. That's why I love these conversations. Even then, I had no clue that was what it was. And when you're hearing doctors and nurses talk around you in medical speak, you're trying to pick up like, okay, what's going on? What do they say? And you hear acute. Okay, my shoulder's about to fall off. This is not acute. This is not small. This is very, very severe. So I appreciate you clearing that up.
Oh, of course. All right, my next one's a fun one. I really like this one because I feel like I'm a lawyer when I say it, but I like to yell out hearsay. That's hearsay. You hear that all the time on shows.
Hearsay.
What does that mean?
So hearsay is an out-of-court statement presented as evidence to prove the truth of the matter. That's like the legal phraseology. All right. In law school, you have to take a class called evidence. And what evidence is, it's how can you sit within the courtroom and properly present your evidence. How can you properly present testimony? How can you properly get certain items into evidence, whether it's Exhibit A, the picture, and Exhibit B, the map, and Exhibit C, the recording. So what hearsay is, and there's different versions to it, it was the bane of every law student's existence in evidence because it's so intricate. But essentially, if I hear somebody say something and I repeat it, that's usually not admissible in court except if certain exceptions apply. And the reason being is because, Long, if you say something to me and I go to court and I try to repeat it, it's more so, why don't we just bring Long in here? Long is not available to sit in the courtroom and be cross-examined and be questioned and have the jury hear what's going on, have the judge hear what's going on. So it's something that is pretty much like you can't vet it appropriately unless there's certain circumstances, if that makes sense.
Yeah.
And this is another instance, maybe an exception. If I have you on the stand and you want to talk about what I said, you might say, well, Nik told me this. Well, that's not hearsay because I'm in the courtroom. I can be called as a witness and I can stand up there and I can say exactly what I said and I can refute it and argue against it. But if I'm not there to speak on it, then it's not admissible because then we're only getting one side of the story, and your side of the story may be completely fabricated. It may be lie after lie, even though that leads into perjury. It could be something that's so far from the truth that it's being distorted. And so that's why hearsay is one of those very delicate evidentiary issues that you really, really want to know and understand before you're going into trial. And it can go as far as recordings and documentation, like the use of documents, police reports, and so on and so forth. So it's pretty interesting. But if you hear somebody say hearsay, it's pretty much, I heard somebody else say something and now I'm trying to present it as the truth to you.
Got it. Actually, and I'm actually going to hijack what you're going to ask me because this kind of is similar. So hearsay is similar to definitions or terms that we use in the medical field, which is subjective versus objective.
Mhm.
If anyone has ever read their physician's note for that visit, there is usually a subjective component as well as an objective component. So the subject component is what the patient says. What is their perspective on the situation? What is their severity? How are they describing their diagnoses? Whereas the objective is what I am physically finding. So what is actually, the patient may say that they have lost sensation in their left hand, but when I do the objective finding and I do the physical exam, there's actually no loss of sensation. Or the patient may say that they saw some redness on their arm, but when I go to look, there is no. So subjective versus objective sounds very similar to what you were saying about hearsay.
Yeah, there are certain instances in which the objective versus subjective standard is there. If I am trying to say that the president of the United States was on CNN and talked about tariffs, right? That is objective, even though the president is not there to speak on the behalf of what's being said. It was filmed, it was recorded. For the most part, we can verify that it wasn't AI. And yeah, there's got to be some proof up, but everybody can sit there and see the video of that recording. But if they said that the president said something about tariffs behind closed doors, okay, now you're getting to the point of hearsay. So there is the objective versus subjective component to it. And hearsay is trying to get rid of the subjectivity that may exist that could sway a court.
Got it.
So,
Well, I will let you take the next round. Go ahead.
Okay. Maybe some of you guys know, but my dog got cancer earlier this year, and he's about to be 9. He's a Rottweiler. He's still alive, but we had to amputate his front leg. When we were going through that process and talking to the vet, there were a lot of words being used that I was just trying to keep up with. Benign versus malignant versus metastasizing, like all of that surrounding cancer. I know I just kind of threw 3 at you, but I feel like they're all in the same category of that medical issue. So I'll open it to you.
So benign, malignant are usually terms that are associated with cancer, but they can be used in most other diagnoses. So benign is where it's not life-threatening, it's not life-changing or altering. So things like a headache can be benign, right? Typical migraine headache, you get it once in a while. That is benign. It's not life-threatening. Whereas malignant, there's an undertone that there is potential for a life-altering or life-ending event like cancer. So if you're diagnosed with, for example, prostate cancer, and it it is near the end stages, then that is considered malignant. Now, when you start using the metastasis or metastasize is when that original disease has spread to another part of the body or another area of the body. So cancer is very common like that. You get prostate cancer and then it spreads to the bone. So then it has metastasized to the bone. Most things, like everyday today things, can be considered benign. Malignant is usually categorized as under cancer, and then cancer can be metastasized to other areas.
Okay. And that's kind of exactly what happened. He had some bumps, and in talking with the vet, these bumps are benign. They're not going to do anything. But then he had also had cancer in his toe, and we got the toe amputated. But that's where the arm cancer originated from. So it was this cancer has metastasized, which was travel. And I was like, what do you mean metastasized? I have no clue what that means. And they explained it. And then it was, and this, if it's not addressed, could end up being malignant. And that's why we need to take the arm if we're going to save his life, essentially. I personally, I've been impacted by cancer from a position of my grandma died from liver cancer, but it happened so fast, we didn't actually get to really experience the nuances of working with the medical staff and trying to figure those things out. So I think that because of what cancer is, a lot of people will at least come into contact with it at some point in their life, and it's important to understand what those words are. So when you're sitting down getting this news, whether good, bad, or ugly, you at least have a basic understanding of what the doctor is trying to relay to you.
And it's a great plug for a public service announcement here from a physician. Cancer screenings is a really good way to get used to those definitions. So when we do screenings on cancer, like colon cancer, we recommend that you get a colonoscopy, which means when you do a colonoscopy, you usually will find benign findings. You will find benign polyps that have not turned into cancer or are not cancer yet. And so that's a benign process. But if you wait too long and you skip your colonoscopies, you do it 5-10 years beyond what you're expected, it may be a malignant finding. You may find cancer that first time you go in and get colonoscopy. So we highly, highly recommend that when we suggest you go get one, which is usually at 45 years old or 10 years prior to your most previous primary relative's colon cancer diagnoses, then we recommend that you do it and you should get it done. You definitely don't want to find cancer in the malignant state or the metastasized stage. Colon cancer is a great example, but that goes for any sort of cancers, right? So you want to make sure you do your breast cancer screening, which is your mammography, as well as your cervical cancer, which are your pap smears, and then your lung cancer screening. If you're a big smoker, you want to do a CT scan. So a lot of screenings that we recommend, and actually, surprisingly, a lot of people refuse because they just either don't know or don't understand the process.
How many people actually do not want to move forward with a screening because they do not want to know if that's something that they're going to have to deal with?
Quite a few people. It takes a lot of convincing, and it takes building that relationship to convince them otherwise, but it's worth it in the end, because we've been able to catch a couple of people who refused initially, but 2, 3, 4 years down the line, after they've gotten to know me a little bit better, I've asked them again and they were willing to do it, and we were able to catch things early. So definitely worth it.
I know with like podcasts, right? You're speaking to people that you may have never actually had a personal conversation with, but there's a sense of vulnerability. I actually recently had to go get a colonoscopy myself, and I was having pain in my abdomen, and they had no clue what it was, and they went in, and this is the joke: the prep work for the colonoscopy was a lot worse than the actual colonoscopy. So having to take your diuretics and visit the bathroom and all that's not fun, but the actual process, they put me under general anesthesia. I woke up. It apparently took only 20 or 30 minutes, and it was, hey, everything's clear. We'll go down the next line of what could possibly be wrong. But I remember leaving, the doctor was like, all right, I'll see you again in 10 years. And I was like, okay, like that is the substance of going to go get your screening early, is the fact that if they find nothing, you're good for a while. And then when things start coming up, as long as you're maintaining, you can get ahead of cancer, hopefully, in the sense of, finding it early and early detection.
Right. And you mean laxative, not diuretic.
What? Oh, okay. There you go. Well, what's the difference? What was I taking?
So you were taking laxatives. So laxatives are medicines to make you poop or make you have stooling.
And what's a diuretic?
A diuretic is actually where it makes you pee out. So urinate.
Oh, okay. So yes, I was thinking a laxative, not a diuretic. See, that's why we do definitions.
That's why we do definitions.
I did that one with the what was it, cirrhosis and psoriasis?
Yep, you got it.
Podcast, yeah.
All right, so I actually have a word for you, and it's called moratorium.
Moratorium is if you have a legal obligation for something, it's essentially like a pause or a freeze while we go figure something else out. So if I have a legal obligation, let's say to pay you a debt, and there's a moratorium on it, it's just a temporary halt, a temporary pause that allows people to go back, figure things out, and then see if it's something that's going to end up being permanent or going back to the original obligation.
It sounds so much cooler than it actually is. Why don't people just call it a hold or a pause? Moratorium sounds like it's like this grand thing. I always thought it was something more.
Yeah, well, it kind of goes to like there's other words too. So another definition I think that you're going to throw my way is injunction. So what's an injunction? An injunction is a legal order to start doing something or stop doing something. So if we're trying to put a freeze on something or halt something, we say, all right, there's an injunction against this, or you're not allowed to evict that person. You're not allowed to shut down the corner store. You're not allowed to start building on that piece of property until we do A, B, or C. And so sometimes there's these like legal words with like these very subtle nuances. And that's why you just don't say, oh, it's just a hold. You got to be official and say it's a moratorium. It's an injunction. Lawyers, right? Lawyers and the
Right,
definitions.
seriously. I think it's your turn. What do you got for
All
me?
right. I am looking at my list because, I gave you three all in a row. So hypoxia. What is hypoxia? If I'm even saying that right.
You are saying, all right, hypoxia is just the lack or decrease in oxygen, right? So we have a definition that defines good oxygenation or good intake of oxygen, which is 90% and above. That can be lowered for people who have chronic lung disease like COPD or asthma. Sometimes that can be lowered to 88%. But hypoxia is basically the lack of oxygen. So if you're starting to run into the 70, 80% of oxygen, you're only bringing that amount in rather than 90 to 100%, then we are worried that you're in hypoxia, which can deplete oxygenation in your blood system, in your red blood cells, which then deliver that oxygen to your brain, to your organs. And if there's not enough oxygen, that can lead to organ death or dysfunction.
Layman's clarification.
Oh,
When you're
yep.
measuring oxygen, is it the amount of oxygen that's currently coming into your body and into your lungs, or the oxygen that's flowing through your veins and through your blood?
So it's the oxygen that is within your blood cells or bloodstream at that moment in time.
Okay.
And that's why you always get when you go to the hospital, they put the little finger pulse oximeter.
That's for oxygen, not for the pulse?
It's both. It measures your pulse and it measures your oxygen at the same time.
Okay. All right. I didn't know that. Learn
Yeah.
something new every single day.
Yeah, right.
All right.
All right.
What do you got for me?
I got habeas corpus. That sounds like something off of Harry Potter.
I think that you might experience the same thing in medical terminology where there are a lot of things based in Latin.
Mm-hmm.
And so as you're going through, you'll get these legal terms that are Latin. Sometimes you can piece your way through it. Other times you can't, and you got to like go to your dictionary and say, okay, what does this mean? But habeas corpus, it's usually preceded by a writ of habeas corpus, meaning that the court is requesting that somebody that's under unlawful detention is brought before the court. So let's say that John Smith is arrested and he's been sitting in a cell for the last 6 months, and his lawyer gets to court and he's like, this person should have been released months ago. The DA isn't doing anything to move the case forward, so on and so forth. Then they'll submit a writ of habeas corpus. And if approved by the judge is basically saying, bring that person who's in that cell to me right now. And it is a no joke. It is right now. Go get him or her and bring him to me so we can figure this out. And that's essentially what a writ of habeas corpus is.
Okay. So it's a document.
Well, habeas corpus is the act. The writ of habeas corpus is like the formal document within court to start the process, I should say.
Got it.
That's another one of those things that very difficult to do because there are a lot of loops you got to jump through and a lot of red tape that you have to pull back in order to ensure that detention is in fact unlawful. Because a lot of times within the law, and I think you see this in society when you're dealing with officers, when you're dealing with government officials, it's just how are you vocalizing and justifying what you're doing? What is it that you're using to justify your action? Reasonable, articulable suspicion is always thrown around, especially when people are trying to, searches and consenting to searches and so on and so forth. So you got to be able to justify and explain why you're doing something. And if it goes against what's the norm is, you have to be able to have answers, or you're going to piss off a lot of people.
Got it.
I actually heard this one. I was listening to a conversation between my wife and her cousin. And, her cousin had mentioned that she was at the hospital and heard somebody say that somebody was coded or code. And I really don't know what that means. It sounds very serious. I feel like I've heard it in very serious situations. But when you hear code or coded, what does that mean?
Yeah, so being coded on or going to a code or patients having a code is when the patient is found down and cannot find a pulse. So you are activating a code, meaning you're activating the medical team to come and do CPR, intubate, or get their oxygenation up because they're most likely hypoxic. So
Yeah.
code is the process or the medical intervention to bring a patient usually back from near death.
Okay, so when you do hear code, it is a serious, serious thing.
It is very serious. Yeah, whether you find them out in a parking lot somewhere or in the hospital, usually when someone calls a code, you want as many people there as possible that are able to help, not just bystanders, but people who actually know how to do CPR, who can document, who can keep time, who can help call for other help, for EMS or other physicians.
It's kind of funny that you threw in that nuance of who could help, because going back to torts and negligence and the duty that you owe others, most people would find this surprising, but at least in Texas, it may be different in other states, but you have no duty to help another. As sad as it sounds, if I see somebody drowning in a lake, I have no duty outside of maybe a Good Samaritan law that, again, gets nuanced because of the state's laws, but I have no formal duty, no legal obligation to jump in and save that person. However, if I jump in and try to save that person, I am then taking that duty on upon myself. And with my current situation and trying to save that person, I might be deterring others to also help. So I can be found negligent in certain situations if I jump in, try to help, and I can't help that person because by my action, I have now prevented others who may have been more fit. I prevented them from actually going forth and helping that individual, which is a weird nuance. But if you're going to help, you better be sure that you can at least help, because you might be preventing somebody else from helping themselves.
And actually, very similar in the medical world is that if I were to see someone on the side of the road, there's always that internal battle. Should I go out and help or should I not? Because the patient could come back and sue. What if you went out, you helped the patient, you pulled them out of the car, but you found out that their leg was severely injured and they ended up getting an amputation later on? So that patient can actually go back and sue the physician that came out to help on the side of the road, because they could say, in that situation, you didn't evaluate everything and you could have saved my leg. There's just so many small nuances that sometimes it causes a lot of physicians to take pause when they're seeing an emergent event out in public. Same thing goes in an airplane. We always joke that when they call on the intercom and ask for a physician or a medical personnel, we're either already drinking alcohol or we accidentally taking a sleeping pill. We just can't help at that moment in time.
Yeah.
Because you never know. It's very rare that it happens, but it's always a worry that patients will turn on you and try to sue otherwise.
We actually studied cases like that where there'd be a car accident and somebody would go to try to help, and as they're pulling them out of the vehicle, they didn't stabilize their neck, so they actually caused more harm to their neck or their spinal cord. And although the car accident was one thing, they then sue the other individual who helped for the additional harm that was done, even though they may have, in the end, saved their life completely. You're saving somebody from a burning vehicle, you end up hurting them, you still can get sued for it, which is just a wild thought when you're talking about Good Samaritans and people trying to do the right thing. All right, who's got the next one? Is it me or you?
I think me.
Okay.
How about dismissal with prejudice and then dismissal without prejudice? What does that mean?
Dismissal essentially is when the court decides to dismiss the case, get rid of it. They're saying, hey, there's no cause for this case to be here. We're dismissing it, and we're not going to entertain anything else from this case.
So is that a judgment's decision, or is that something that either party is requesting the judge to assume? Is that something that needs to be brought up to the judge, or the judge can, out of the blue, decide to dismiss?
So judges have a lot of authority. And it goes to, I think, one of your keywords that was thrown my way is also appeal, right? So if we're looking at the court system, you have your lower level courts, you have your appellate courts, and then ultimately you could have the Supreme Court of the state or the Supreme Court of the country. But when you're looking at a dismissal, what you're essentially saying is, if I am defending a case and I just got sued and I think there's no reason why this person should be suing me, I can then file a motion to dismiss and then bring forth evidence or an argument before the judge that states why it should be dismissed for whatever reason. There's not enough evidence. The lawsuit was frivolous. It was somebody completely different. You guys have the wrong person. So what'll end up happening is the judge can make a determination based on that motion and say, all right, your motion's granted. We're going to dismiss this case. Or you could be in the case and something could get brought up and the judge might start asking the lawyer's question and say, now that I'm looking into this and now that I'm hearing this testimony or now that I've talked to this certain client, I'm actually just going to go ahead and dismiss the case. I'm finding that there's no reason for this case to be here. So I'm just going to dismiss it. What you have to worry to bring it back on is a lawyer appealing the case and then going to the higher court, the appellate court, and saying, the judge below made the wrong decision. I would like you to review the case and make a ruling on it. Sometimes the appellate courts will make a ruling. Sometimes they'll make the lower court retry the entire case. Sometimes they'll say, nope, sorry, we agree with the lower court's ruling. We're not going to do anything. Now, where the prejudice and without prejudice comes from is if it's dismissed with prejudice, the case is completely closed. You are not allowed to refile. You're not allowed to do anything else with it. Prejudice is a very aggressive word. It is an aggressive way of doing it. You're not allowed to bring this case back to us. You're not allowed to refile. If it's saying that the case is dismissed without prejudice, if you need to refile, you can go ahead and refile. If you need to refile and get it right, you can go ahead and get it right. I use an example. My dad used to have a business and he ended up selling his business and it was an LLC and then the LLC ended up getting dismantled. So for 3 or 4 years, my dad did not touch the business at all. Well, a man came back and sued him for the work that the business had done, but sued my dad directly. Well, he was protected under the fact that his company was an LLC. So he went to court and basically said, Your Honor, he should be suing my company. He should not be suing me. I have nothing to do with this company for the last 3 or 4 years. It's actually no longer even in existence. So I don't know why I'm here. And the judge said, well, that actually makes a lot of sense. Looked at the other guy, said, if you'd like to sue him appropriately, you need to sue his company, not him. I'm dismissing this case. It wasn't dismissed with prejudice because that guy was entitled to go back and refile appropriately. And then my dad would have to show back up and then have another argument as to why. But essentially, that was a real world situation of something getting dismissed because the ducks weren't in a row. Nothing was aligned. And, that's sometimes what happens in court.
Did the guy end up coming back?
Nope. Okay. And it was small claims. And it was funny because when you're a lawyer, and I'm sure with you being a doctor, family always wants help. Friends always want help. They're always asking opinions. And my dad hit me up. He's like, hey, can you go ahead and show up in court for me and appear as my lawyer? And I said, absolutely not. This is small claims court. I got a day job. You just need to go and explain your situation. And trust me, the judge will be on your side. So you don't have to worry about me showing up for you. But they're always looking for that little piece of advice. And I like giving it. I like helping out friends and family. That's why I went to law school. But I'm sure as a doctor, you can relate to people always asking you questions.
Well, yeah, I'm one of those people that have asked you for help. So I appreciate it.
Likewise. Which then goes to my other question, because we actually brought this up with you. So my wife is pregnant. She's 6 months pregnant and she's anemic. So we actually hit you up after finding that out to ask you about anemia and everything we should worry about. So I feel like this is an appropriate time. What is anemia? What does anemic mean?
Anemia is the diagnosis. Anemic is the state. So anemia is the low blood count. If we are looking at a tube of blood, there are usually components that we can break down the tube into. So white blood cells, red blood cells, platelets, and then a whole bunch of other things too. Red blood cells is what anemia is associated with. Red blood cells are the cells that bring oxygen to your organs. We've already talked about that. And if there is a decrease in number of red blood cells, then that means there is a decrease in blood cells floating around, as well as blood cells that are holding oxygen, which can lead to a lot of other detrimental things like fatigue, loss of weight, loss of appetite, etc. Now, getting into what causes anemia, that is a whole nother topic. It's a whole conversation that we can have, but there are multiple things, whether that's due to blood loss, whether that's due to iron deficiency, B12 deficiency, folate deficiency. There's so many different reasons that can cause anemia, but the majority of the time, the most common causes are the iron deficiency or blood loss anemia. So I think in your wife's case, it was iron deficiency, which is very common in pregnancy, and therefore the suggestion was to take some iron supplements. We had talked about side effects of iron, which is constipation, and so we decided we could either do it every single day if there wasn't any issues with constipation, or we can do it every other day to help limit, because the data now shows that your body absorbs similarly whether you take it daily or every other day. Enough of it. Yeah. So that's anemia.
There's also the nuance of her doctor recommended that she has to take her iron pill with orange juice, because apparently there's a reason for that, and opposite the when she's taking her prenatals and her other pills. So it's always like you open up one door and then you go into like the next door and the next door and the next door. It's just never ending because there's always a side effect or a more efficient way to do this, that, or the other. So
Yep, you got it. So my next word for you, I think we only have time for a couple more here, but admissible. Admissible in court. I feel like I hear that a lot on a show too.
yes, admissible is essentially it is allowed in court. So we talked about evidence and we talked about the ability to get certain things into evidence, whether it's testimony, the photograph, the bloody weapon, or the OJ's white glove, right? Can you get this piece of evidence into court? Is it admissible? So is it allowed? One thing that you have to remember is that if you have a jury or even the judge, but specifically a jury, if you're putting evidence before them, their job is to judge that evidence in the grand scheme of the trial. So if something is admissible, it means we can bring it forth and it can then be judged by the powers that be, the jury or the judge. So if something is inadmissible, it means that either per the rules of evidence, it's not allowed. So we talked about hearsay. Certain statements can be made, but not admissible because that person's there. So when it comes to court, sorry, we can't bring that in because the rules don't allow for it to come in. One thing that I think it rides that line of admissible versus inadmissible is lie detector tests. And so there are some states or some areas that lie detector tests, the results are admissible in court. The way that I was taught, at least in the state, and I don't know if things have changed since then, is that lie detector results are inadmissible in court. Why? Because the nature of a lie detector test isn't necessarily to detect lies, but it's to detect differences in physiology, whether it's a heart rate or sweating, which those things can be caused by other issues, not just lying. So that's an example of why something would be inadmissible. Now, you can go through some leaps and bounds of maybe bringing in the person who administered the test, talk about what they found in the test. But again, there's different rules and evidentiary proceedings that may occur to get something into court or to keep something from coming into court. All right, Long. So now I'm going to hit you with some of the fun doctor slang. So my first one, we were talking about coding, right? What is a code brown?
A code brown. There are a lot of different colored codes within the hospital. Code red, code silver, code blue. Code brown is usually when there is a bad spill of some sort, so a chemical spill or a dangerous spillage. However, I guess within the nurses and the people who work in the hospital who are more of the jokesters, code brown is usually code for someone just pooped themselves, or there's a cleanup in a specific patient room that will require a mask and gloves and a lot of muscle.
So when it comes to a code brown, if you had let's say you had a code brown in the middle of Target, obviously you're probably having like a custodian or a janitor come over and clean that up. If you have a code brown in the room, are nurses responsible for the cleanup, or are you also bringing in like custodians to help out? What's the situation there?
This is why nurses are worth their weight in gold, because yes, they are the ones to clean the physical patient, right? So they are going to go in there and clean the patient themselves, because usually the patient who has had a code brown, it's because they are immobile, they're not able to get up on their own, they're not able to clean themselves. So that's where the nurses play such a big role in helping our patients on a day-to-day bedside next to the patient. But the custodians, will then also do their job, which they're also very helpful, is keeping those patient rooms clean. And so they'll come in and they'll clean the floors and the beds. And usually we'll actually trade out the beds and the sheets, of course. But custodians are so important in the hospital system and any medical system because they keep everything clean. They help prevent spread of disease by keeping things sterile.
Well, thank you for walking us through that.
Yeah, right. How did I know you were going to ask something like that?
Have you ever just yelled out in your home when one of your kids has an accident? We got a code brown.
No, not at all. But I will say that in residency, one of the passive rite of passage is to disimpact an elderly person's behind because they're coming in completely impacted with a poop.
Wait, what do you mean by disimpact? Okay, another word, disimpact.
Disimpact, going in and removing. So we are literally going in with glove and finger and trying to help the patient poop because they have not been able to pass along their stool with the laxatives or suppository. Sometimes it's needed.
So it's not that they've pooped themselves and you're cleaning the underwear. It's that you're actually physically
not able
taking
to
your
poop.
finger.
Yep. They are not able to poop. It's balled up and it's rock hard at the very end there and it's not coming out. So they need help birthing that little baby, that poop baby.
So did you guys pass it on to other students where you're like, I've disimpacted, it's your turn, like this is your rite of passage now because I've been there, done that?
Kind of yes and no, because when you pass it on to a student, you have to be there in the room with them because you can hurt the patient too. So you want to make sure you're doing it appropriately and correctly and that you're listening to the patient when they say it's uncomfortable or it's painful.
I could never be a doctor, man. Well, I'm just saying, I could never be medical. The stuff that doctors and nurses and medical professionals, what you guys have to deal with, y'all are saints. Because, yeah.
All right. Our next word for you. I don't really have any fun ones, but let's see. Statute of limitations.
A statute of limitations. A statute is essentially a law on the books. A statute of limitations is basically how long you have to file a lawsuit or pursue criminal charges against somebody. Let's keep it really simple. Let's say that there's a statute of limitations for somebody trespassing on your property of 2 years. Well, if somebody trespassed on your property and you want to sue them civilly, you have 2 years to do so. So you can wait and buy your time. And at the last second, you can file, get them served, which is the act of serving them your formal filing. If it's outside of the statute of limitations, nothing can be done. Nobody can sue you. Nobody can pursue criminal charges against you. There's different rules for the different laws and the different torts and the different criminal acts. And again, not legal advice. Do not take anything I say in the next, 30 seconds as gospel because every state is different. Every community is different. Every city is different. But let's say that you stole a pack of gum. Your state statute of limitations on stealing might be 4 years. So then after 4 years, you don't have to worry about criminal charges coming your way. But for those 4 years, they can still file charges and it could be 3.5 years later and all of a sudden you're being pulled before criminal court because you stole that pack of gum. But also there's societal standards where sometimes there's no statute of limitations. So for instance, murder. Murder is one of those serious, heinous crimes that we don't want a statute of limitations on because we don't want you to think if I kill somebody and I just go on the run for 2 or 3 years, after 3 years, I can come back and I can't be charged criminally for this because the statute of limitations run out. So there are crimes in which the statute of limitations does not exist or it goes on forever and ever and ever because they want the ability to still pursue somebody for a heinous act or such a severe crime.
Wait, so is that movie, what's it, Double Jeopardy? Is that for real? Like, where you can't be tried for the same thing twice?
Yes, so that's something completely different. Statute of limitations for somebody to sue you or the state to pursue criminal charges against you. Double Jeopardy is exactly what you said. You cannot be tried for the same crime twice. So if I am tried for that pack of gum and the jury finds me not guilty of stealing that pack of gum, they can't turn around and then say, hold on, wait, we found more evidence or we got a different jury or we got this, that, or the other, and now we're going to do it again. We're going to run it back. You can't do that.
Unless the case was dismissed. unless the case was dismissed without prejudice.
Yes, yeah,
Look at that,
the
I'm
case
learning.
is dismissed without prejudice. There you go. And then, of course, there are other like weird nuances that exist where if you find out that there was witness tampering or something severe occurred or there was somebody who perjured themselves, then you might be able to go back and say, hey, look, the person may have been tried for this the first time, but the manner in which they were tried was inappropriate. We need to run it back. And then at that point, you might be getting the appellate courts involved to make the ruling on what could actually happen. So it's pretty interesting. And yeah, I saw that movie years ago. Wasn't it where she was put on trial for killing her husband? And then her husband was actually alive still. He had faked his own death.
Yep. So she went and actually killed him, and she couldn't get tried.
Yes, that's right. Because she had already served her time, right? She had gotten out and then found him.
We're going to rewatch that movie. It's pretty good. One last one for you. Why don't you pick one, and that will be the last medical term that we go. And we can always do another episode if we have more input from the audience and from the listeners.
I think we should, because I really like the terminology. I think you get to learn a lot, and it brings clarification. So another fun one, no offense to these individuals out there, but what is a frequent flyer?
Frequent flyer is a term that people in the medical field use for patients who come back very, very often. We're not talking about once a month. We're talking about every other day, sometimes daily. And they usually come back for the exact same issues, whether that is someone coming for pain meds, they're coming in to ask, or frequent flyers can be alcoholism, right? So they're coming in because they haven't quit alcohol. So they are frequent flyers, and that's what we term patients that they're coming back so often.
So do they collect frequent flyer miles?
No, absolutely not. But it can be hard to treat those patients because you're seeing this endless cycle where you're trying to help the patient. They don't want to help themselves. They're just getting there to get the care they need to get back to where, they can walk out of the room and then go back to doing what they landed them in the hospital in the first place. Unfortunately, it's really sad that we see those. I wish we had a better system to help those sort of social aspects, because it usually is revolved around drug use or alcohol use, and it stems from some sort of lack of or something missing in their life. So I wish we as a system and a society were able to help those patients a little bit more. Yeah, but not to turn that serious or anything.
To tie our podcast together, I think that's important, because previously we've talked about how some of your salary is based on how many patients you see. So can those frequent flyers impact the salary in that manner, in which they kind of go with your metrics of how many patients you're seeing and how often you're seeing them, and impact your bonus structure and so on and so forth? Like, could that one individual like really detrimentally impact or positively impact any of that?
Of course, if it's someone that's going to be coming back every other week or every week in an outpatient setting, they're going to boost your numbers. Especially if you're just starting out in a new area and you suddenly collect 10, 20 new alcoholic patients, and you need to see them once or twice a week, or maybe just 2 times a month to manage their illness or their medications, then yes, they're going to add to that pool. But once you have a full panel, then they can be a detriment, because then now they're patients that are taking time from other patients. Maybe these patients are not wanting to follow through with the treatment plan, and they're struggling. They need a specialist, but they don't want to go see the specialist. So it's nuanced. It's hard to say whether they help or they hurt. But in certain scenarios, they definitely can help, and in other scenarios, they definitely can hurt.
I like the clarification there.
But I think that's a great place to end. That's it for this episode of the Medico-Legal Brief, where medicine meets law. If you liked what you heard and you want to share it, follow, comment, we would really helpful for our episodes moving forward. If there are any new topics or other topics that you would like to hear from us, please let us know. That's all we got here with Dr. Long and Lawyer Nik.
Yes, we're doctors. Yes, we're lawyers. No, this podcast is not medical or legal advice. Do not take anything we say as a reason to perform your own heart surgery, represent yourself in court, or diagnose your neighbor's rash. This is for entertainment only. Think of it like hanging out with your smartest, wittiest friends, not a substitute for an actual appointment. If you act on anything we say without talking to your own professional, that's on you. Seriously, don't do that.